Hi guys, my name is Matthew Giovanelli, and today I'll be talking about defense attorneys and bias mitigation. Thank you for taking time out of your day to listen to the essential discussion on biases in the courtroom. As defense attorneys, their role is to safeguard justice, but unconscious and systematic biases can undermine even the most well-intentioned efforts by lawyers. Today, we'll explore how those biases emerge, their impact on legal outcomes, and practical strategies ourselves and even defense attorneys can use to identify, limit, or even eliminate these biases in courtrooms. My goal with this video is to empower you with the knowledge and tools to ensure that every client receives a fair trial, regardless of their background, race, or identity. Biases are prominent in everyday human life, whether those biases are about sports teams, brands, personal items, other people's personality traits, or even the races of other people. Biases profoundly impact day-to-day life. They can influence people consciously or unconsciously when they're making decisions. Biases in legal settings are much more difficult to recognize, as most of the biases that are exercised in legal settings are unconscious. Nevertheless, for our legal system to be fair and complete, these unconscious biases must be eliminated or limited to promote fairness and justice in our legal system. For defense attorneys to be able to uphold our justice scale and uphold the innocent until proven guilty standard, they must understand what types of biases are. Explicit bias is a conscious and deliberate bias that is thought about openly, prejudiced statements or actions. An implicit bias operates unconsciously, which is the majority of the types of biases we will see in a courtroom. They are shaped by societal stereotypes and personal experiences. Even professionals such as judges or lawyers that are committed to fairness can be influenced by implicit biases without even realizing it. Now, defense attorneys may be thinking to themselves, I am not biased, so I do not need to worry about biases being prominent in a case for a person I am representing. But that is hardly the truth, especially with how lengthy criminal justice system processes can be. Because of all these moving parts and different stages in a case, biases can infiltrate every single stage of a case. For example, in investigations, leading questions or suggestive environments can distort witnesses and suspects' memories, sometimes leading to false confessions or unreliable testimonies. In charging and plea bargaining, prosecutorial discretion and defense triage can be swayed by stereotypes or resource pressures. In jury selection and deliberation, jurors bring their own implicit associations, which can affect their perceptions of defendants, witnesses, and even attorneys. And in the sentencing process, studies show that implicit racial biases can lead to harsher penalties for minority defendants, even among judges who consciously strive for fairness. The most important sections where biases can impact the results of a case is during the investigative period, pleading of guilty and not guilty, and the jury selection and deliberation process. The first main topic I'll be talking about where biases can impact a legal situation is leading questions in investigative interviews with defendants or accused. First of all, what is a leading question in an investigative interview? A leading question is a question that prompts someone to provide a predetermined answer, implies the desired answer within the context of the question, or can be drawn from assumptions and biases. For example, if you were looking at a test and someone asked you what year in the 15th century did Christopher Columbus arrive to America, you would know that it would be in the 15th century because the question was prompting you to know that information. In interviews with witness or suspects, leading questions posed by law enforcement members can severely influence the testimonies given by witnesses or suspects. In extreme cases, these leading questions can lead to false confessions and even possibly distorted memories of the events that unfolded. Previous research has highlighted that leading questions can present wrong or incorrect information to suspects or witnesses, which then impairs these suspects or witnesses' recollection of the events. This was studied by Loftus in 2005 and Goodjohnson in 2003. For example, when interviewers suggest specific details, the information could be incorporated into a witness's recollection of events if the witnesses did not initially recall it from their memory, which was studied by Loftus in 2005. This phenomenon has been highlighted before in previous research and has been deemed the misinformation effect. The misinformation effect profoundly affects how witnesses actively recall things after they witness them, emphasizing the importance of interviewers using open-ended, non-leading questions when conducting their interviews, which was studied by Walsh and Bull in 2015. To show statistical evidence of this misinformation effect, a study done in 2016 by Cochran et al. Showed that when witnesses were exposed to altered versions of their own memory of an episodic detail of an event, their memories changed to be consistent with those altered reports. Because of this research on the misinformation effect and how leading questions can lead to the misinformation effect and even impact the testimony of witnesses and suspects, there needs to be a better way that lawyers can attest that their suspects or witnesses are being questioned. Coercive tactics, or even if there are other people in the room where the interview is being held, can lead to higher rates of false memories and confessions. To help with these factors and eliminate some of these biases, interviewers need to promote a comfortable and supportive environment that has been shown to increase the accuracy of memory recollection. Previously discussed, leading questions in interviews can affect how a suspect or witness gives their testimony, as leading questions tend to promote false memories or inaccurate memory recall. A better way to conduct these interviews to promote more accurate memory recall, to limit false confessions or planted memories in suspects and witnesses, is the method of the cognitive interview technique. Cognitive interviews are made to promote the accuracy of testimonies given by witnesses or suspects by using methods that help suspects or witnesses recall the events more transparently and accurately. Some of the techniques used in a cognitive interview ask for witnesses or suspects to describe the events that occurred in specific detail, to think of what they witnessed from a different perspective or location, and use visual aids like photos of the place to aid their memory recall. This was studied by Willis in 2015. In research settings, results of cognitive interviews have shown that witness testimony has been more accurate and complete because of the removal of influence from external factors, which was studied again by Loftus in 2005. Defense attorneys, this information is incredibly important to you because using cognitive interview techniques in legal settings will allow witnesses or suspects to provide a much more accurate recollection of information than interviewers using leading questions. Defense attorneys, by using this cognitive interview technique, it has been shown that allowing witnesses to discuss their memory of the events that occurred in their terms, timetable, or order without interruption or additional questions reduces the likelihood of false information being presented in their memory recollection of the events. And as defense attorneys, it is your job to promote the most justice and fair trial for your defendants that is possible. Defense attorneys, to promote the cognitive interview technique, make sure that you are there always whenever your defendant, witnesses, or anybody else related to the case is being questioned by the police. To be able to follow the cognitive interview technique, aid the witness to recall the conditions or environment in which the event took place, ask for witnesses or suspects to recall the events that happened backwards to promote memory recall, encourage witnesses or suspects to provide all the details they can remember, even if they deem them significant or not, and finally ask suspects or witnesses to give their recollection of the events again using any visual aids or any other tailored techniques. Although the most prominent places for biases to be presented in a legal situation is through eyewitness testimony or false confessions, jurors also have biases which can drastically impact trial outcomes or even decisions. As a defense attorney, you can make additions or subtractions to whatever jurors are present in front of you in a court case. So it is important for you to understand the certain biases that jurors may possess so that you can remove all outside biases and factors and focus on the evidence and defending your client. Although jurors are asked to remove all biases and previous information about a case, it has been found that biases can drastically impact verdicts in trials without instructions given to jurors about removing their biases, which was studied by Mitchell et al. In 2005. In other research on this topic, it has been found that if certain jurors have implicit biases about ethnic or racial groups, these implicit biases can impact whether or not jurors perceive the suspect as innocent or guilty. For example, there has been research done on the availability heuristic and jurors' decision-making processes. The availability heuristic is when jurors overemphasize the importance of specific yet rare events during the case, leading to jurors make biased decisions. There are many other types of psychological biases that influence jurors. For courts to help eliminate or mitigate these biases, legal professionals must be educated on these topics and promote specific interventions to dissipate these biases' impact on the outcome of trials. To help mitigate or eliminate these biases present in juries, courts can implement strategies such as presenting judicial instructions that promote impartiality and promoting a more diverse selection of jury members. Research has also shown that when juries deliberate to discuss their findings from the case, if there is a promotion of open discussion that includes different or diverse perspectives, implicit biases can be mitigated or even eliminated. This information is necessary for defense attorneys to understand and know because removing biases from a jury selection process is incredibly important to getting the verdict you deserve and your client deserves. As defense attorneys, you are the backbone of the American justice system and a backbone of the innocent until proven guilty statement. This video's purpose was to help you understand and educate you on the certain biases that may be impacting trials in court, and also how to mitigate or even possibly eliminate these biases for a fair justice system that treats everyone equally. If defense attorneys genuinely understand the role of conscious and unconscious biases in legal settings, they can promote a fair justice system. This justice system would allow for accurate memory recall by witnesses and suspects, eliminate false or forced confessions, and promote diversity among jurors. Thank you so much, and thank you for listening to me today.